Welcome to SST College of Arts and Commerce. This is SST Edupedia. Myself, Assistant Professor Sunil Shah. Today I will be covering up the topic called contract by the person of unsound mind, which is there in the class of first year BMS and the SEM 1, and it is there in the unit 1, as well as same topic is there in SYBCom SEM 3 under the subject called business law. Students, you are aware, whenever the person proposes, then that particular person who proposes is called the proposer, and the person who accepts that particular proposal would be called acceptor, and the proposal plus acceptance is equal to agreement. Now the question comes into mind, what is contract? Contract means agreement enforceable by law. It would be called as contract. There are some contracts which are been by the person of unsound mind, insolvent or lunatic or some other cases, or by the corporation. Today in this particular video I will be explaining you about the contracts which are done by the person of unsound mind. Students, you have to understand what are the essential elements of the contract. I want to make your revising you about the essential elements of the contract. First point is that there should be offer, there should be the person who makes the offer is called proposer, and the set of promises which forms the part of agreement would be called as the agreement, and this agreement would be supported by consideration, that is the third element. Agreement plus consideration is equal to contract. Then the next part would be called as CP, that is called the capacity of the parties. The person should have the ability to understand to the terms and conditions of the contract is called the capacity of the person, followed with the consent. Consent should be given, which should be free. The consent should be obtained, should be free. If the consent is not obtained free, then it would be considered as a voidable contract that can be avoided into the court of law. The next part is called as possibility of performance. Possibility of the performance which is mentioned in the contract should be abiding to the rules and regulation. The contract should be able to perform by the other party, then only it would be called as the valid contract. Next point would be called as lawful consideration and the lawful object. So the main essence of the contract should be the consideration which has been obtained, the object of the agreement should be lawful, and the consideration obtained during this particular agreement would be also lawful. So lawful consideration and lawful the agreement and lawful object are also the essential parts of the validity of the contract. Now coming into the section 12 of Indian Contract Act 1872, which defines a person who is a person and called as of the sound mind, and who is the person who would be called as unsound mind. As per the illustration given here, a patient in a lunatic asylum, when he has been treated, who is at the interval of sound mind and sometimes is of unsound mind, and the person contracting during his soundness of the mind, that would be called as a valid contract. But the person, when he enters into the contract when he is not of unsound mind, then the contract would not be valid. The question comes into the court of law, whether he has entered into the contract when he was in the state of mind or not in the state of mind. It depends upon the merit of the case, and the judge, the court has to decide whether the contract is valid or not valid. A sane person, that means a person who is having a good knowledge, who is delirious, who is thinking in different way, and has suffering from a fever, or who is in a state of intoxication, that is, he is in the state of drunkenness, that he cannot understand to the terms of the contract, or forms a rational or couldn't form a rational judgment as to its effect of his interest, can contract while such delirium or drunkenness lasts. That means the statement, the meaning of this particular statement is that he can enter into the contract when his state of intoxication is not there. That means he is free from that drunkenness, or he is free from that delirium, that is that particular stage when he is having that particular fever, that is having some psychological effect. When he is free from that particular effect, then only he can enter into the contract. So the borderline of difference is that the person, when he is in the state of intoxication in the evening, when he is in a drunk, he cannot enter into contract, but in morning, when he is in the good state of mind, he can enter into contract, provided he drinks in the evening. Unsound mind, It depends upon the doctor who issues the certificate whether he is a sound mind or unsound mind. The doctor who issues the certificate should be a civil surgeon, and he has the capacity to sign that particular the authority or a particular that letter that he is free from the soundness or unsound, or whether is a sane person or an insane person. Normally the person who is MBBS or the person who is having a master's degree in medicine from a valid university can certify that person, then only he can enter into will agreement or he can enter into any type of agreement. So the person who are in the state of intoxication, or the person who are in the state of drunkenness, or in the person who is in the coma, or any other person, when that particular effect is removed, he can enter into contract that is mentioned under section 12 of Indian Contract Act 1872. Contract by the person of unsound mind, coming to the same section. A patient is a lunatic asylum who is at the intervals of sound mind may contract during those intervals. A sane person who is delirious or who is in a state of drunken, he cannot understand to the terms and conditions of the contract and cannot form a rational judgment. That means he has been in the state of intoxication, his mind is not free, he is not able to make the rational judgment, he cannot understand to the terms and conditions of the contract. He cannot read or he cannot get and explained by the person who is making him understand, because his mind has been controlled by some other person or some other effect is there. Till the effect lasts, he cannot enter into contract. This is how the brain of the person goes. That means he is not in the state of understanding the things or the points or the items which are mentioned in the contract. Coming to this, the next important part which is there, which is mentioned under the Contract Act, the contracts by Purdanshi Woman. This particular types of women are found on those areas where they are been living away from the society, but they are allowed to enter into contract subject to the following terms and conditions. The Purdanshi lady is separated from the society. That means she is away from the society. She is been remaining aloof from the society. She doesn't understand to the what is going on in the world. That is called a Purdanshi woman, who is separated from the society due to the customs or usage of a particular community. It can be any community, but the main crux of is that he should be or she should be separated from the society due to the customs or usage of a particular community. She is not allowed to mix freely in this society. That means due to the customs or the traditions of that particular community, she is not allowed to move freely. While entering into the contract by the Purdanshi lady, it should be well established law that the deed or the agreement was explained to her by the other person in that particular language or that particular mode where she can understand properly, and she had entered into the contract after she had understood that particular statements and all the terms and conditions mentioned into that particular deed or agreement. Otherwise, such an agreement is set aside by the court of law when she takes that particular objection that she has not understood the terms and conditions of the contract, and the judge will abide to that particular statement only if she proves into the court of law that she is away from the society due to the customs or tradition, and she should have that particular tag of Purdanshi woman. And the consent which has been obtained in that case, if her consent is not been given properly, it is not a free consent. That means that particular contract would be void if she takes the stance in the court of law. While entering into the contract with the Purdanshi lady, it should be established that the deed was explained to her and she had entered into contract after understanding to the terms and conditions. She should say that whatever is mentioned, I had understood in that particular language where I am knowing it. That means the person who makes her sign, she should sign, and before signing she should write, I had explained and it was been understood. So two statements she should write. That two particular words should be very, very important, which makes the important aspects related to the contract, that I had understood and explained. So first point would be explained by that particular person and she had understood. If one part is missing, then that contract would not be valid. Otherwise, such an agreement is set aside by the court and she can avoid on the ground that the consent obtained was not free. That means it is called as voidable contract. Coming to the important aspect that is related to the contracts by corporation. Students, you are aware corporation means a company, or company, what are the characters of the company is that they should have perpetual succession, there should be transfer of the shares should be free, it should be registered with the ROC or with the ROF or with the ROC of the LLP, there should be the common seal which should be much more useful, and the corporation, as you are aware, it is an artificial legal person. So the company runs with the help of the board of directors, and the company can buy its properties on own name and they can be sued and can be sued. So corporation is an artificial legal person. So once the board of directors are natural person but the company is a legal person, so company cannot die a natural death unless until it has been bound up by the court or the company gets a voluntary winding up. A corporation is an artificial person. It is created by the law as per the Companies Act 2013 or the previous company which have been formed under the Companies Act 1956 or by any other legislation which has been passed by the parliament when this session is in moving. The corporation, being the company, can enter into contract by its own name. That means the company can enter, suppose a company like a Tata, they can enter into contract with Reliance, or the Reliance can enter into the contract with any of the company like PNG. But there are two limitations on the contract by corporation. Coming into the next slides, whenever the contract has been signed by the corporation, we need to have two particular limitations which I am covering up in the next slide. The natural limitation, it is due to its nature. So as you remember, as you are aware with that particular word natural limitation, it should be through its nature. Corporation, being an artificial person, can only contract through its agent. So company can sign the document through its board of directors. That is, board of directors are the agents of the company, and the board of directors have been given the power during the AGM. When the AGM has been held, all the shareholders use the power, that is through special power of attorney or through the general powers. They have been given, assigned the task to sign all the documents if it is in the good faith and running of the country of the company. Directors are considered to be agents of the company, and directors can contract on behalf of the company, which is as mentioned under the company seal of the company and signed by the director as an agent for the company. So the directors can sign on behalf of the company for the benefits of the company, for the betterment of the company, or for the betterment of the shareholders. Contract by the corporation, the second part, in the previous slide I explained about the natural limitation. Now I am speaking about legal limitation. The corporation cannot contract beyond the powers defined under the memorandum of association. Students, in the previous classes you are aware what are the clauses under the memorandum of association. That is called as a public document which can be accessed by any person when they reaches to the ROC. The ROC, after paying the amounts, the fees which has been fixed by ROC, any person can check the memorandum of association which has been kept in the ROC's office. The clauses which are there in the memorandum of association are capital clause, liability clause, object clause, name clause, subscription clause, and the registered office clause. That means 6 clauses are there in MOA, which is as a public document. So whatever the definitions and whatever the rights are being given has to be mentioned in the memorandum of association. Supporting to the memorandum of association is article of association. If by any mistake or if anything is going wrong and the company feels that to support with the articles of association, and if these powers are been given to the directors, and if the directors works on that particular agreement, and if the powers are been given, then he can abide with that particular agreement. A contract which goes beyond its powers. So if the powers are not mentioned in either in memorandum of association or article of association, then it would be called as ultra virus, that is acting beyond its power, and this particular agreement would be called as void. So there would be legal limitations. Legal limitations are those limitations which have been abided by the law. You cannot go without beyond the powers of memorandum of association or article of association in case of company, and same thing applies that the time limit has been fixed for each and every document. Contract by insolvent. So the person who has been bankrupt or insolvent, they cannot enter into contract. As you are quite aware, the insolvent person doesn't have the capacity to enter into the contract. An insolvent or bankrupt person is disqualified from contracting during the insolvency. Once that particular insolvency has been removed, that particular tag has been removed, then he can enter into contract. But he has been certified as an insolvent by the board of Insolvency Board of India, then this particular person cannot enter into the contract. The contract by the insolvent, all his assets vest into the hands of official assignee. Whoever the official assignees that have been appointed by the ROC or by the National Company Law Tribunal or by the Law Tribunal, then this particular official assignee would be coming into the footsteps of the directors, and he would be acting as a director for that company. His decision would be final and binding, and he has to report to the ROC as well as National Company Law Tribunal when he is doing all the activities related to the transfer of funds or paying to the creditors or the debtors, and or the receiver. In some cases, the court receiver has been also appointed by the court, and he steps into the footsteps of the director and who enters into the contract on his behalf. Then this type of contracts are also been allowed. So the contract by insolvent, contract by the official assignee or the court receiver is also been valid into the eyes of the law. Thank you from my side.